Hi everyone, and welcome to this mediation webinar today. If you could just let us know that you can see and hear us, that would be helpful. There's also a Q&A box, as well as a place for chatting and asking questions. Thank you for joining this webinar and taking time out of your day to participate and learn more about family mediation. What I intend to cover today is really to look at what is mediation and how do you prepare effectively for mediation. I intend to go through a pause principle, which I use in my mediations to really focus you in on looking at the future and how you can effectively prepare for and conduct a mediation, whether you're a professional, a lawyer or a mediator, or whether you're a party who's going through separation. So as I said, today we're going to be looking at the, demo. So this is a bit about myself. I'm Fiona Kirkman. My background is as an accredited specialist in family law. I'm also a family mediator, and I have a legal technology company and have done some lecturing over the years as well. So I have quite a diverse background, but I've been in the family law world for approximately 16 years. And I really believe strongly in resolution without court through family mediation, as well as the utilisation of legal technology to help with the admin work, enabling you as a professional and a party to focus on outcomes instead of being tied down with admin. So the pause principle, as I said earlier, is going to be the focus of the mediation today and how to effectively prepare for family mediation. So I use this pause principle to pause and really think about where have you been, where are you currently, and where do you want to be in your relationship, or preparing your clients for those things. Where have they been, where are they currently, and where do they want to be? To really look at being future focused, but also acknowledging where they've come from and where they are at the moment. Also with this pause principle, it's an acronym for the importance of P, preparation, which I'll go through in more detail. A, the importance of affirming relationships. For example, if they do have children, whilst they are no longer partners, they will always be parents to their children, no matter what age the children are. And so it's really important to have a good effective co-parenting relationship. Thirdly, the importance of understanding interests. Sadly, in family law, sometimes people can get bogged down in positions and this is what I want, this is what I'm entitled to, this is what the advice is, so I want this. What I encourage in our family mediations is really to look at the why. Why do you hold those positions? And what is in the best interests of the children? Not just you and the other party, what's best for you, but if there are children involved, looking at what is in their best interests and what is in the best interests of the family as a whole. So I'll go into more detail with that today as well. S, searching for creative solutions. Again, not focused on what's your position, what's the other side's position, but really looking at how you can creatively resolve the matter that perhaps is an outcome that's suitable for not just you, but the other side, and in particular the children and the family as a whole. Before you then evaluate options and reach an agreement. It's really important when you evaluate those options to look at not just what is the likely outcome as far as the advice that you might have had on what the likely property settlement or parenting arrangements might be, but what is the impact of that by way of the time involved, the cost involved, the stress on you and the stress on the family as a whole. So really, we'll go into some details as to how you can effectively evaluate those options when you're preparing for family mediation and being involved in that mediation. And lastly, reaching an agreement and the importance of formalising that agreement and how do you do that. So if you have any questions, please let me know, and we'll allow some time for questions, a Q&A at the end. Okay, so the first principle, preparation, is the key to success. You may have heard this said, and it's very true to family law and family mediation. I find in the mediations that I conduct, the parties and the lawyers who effectively prepare for mediation and have exchanged the required documents in sufficient time prior to the mediation, and who have emotionally and prepared their clients for the mediation, are in a much better position to have a successful resolution at mediation. So how do you prepare effectively for mediation as a professional and as a party? A few principles. Firstly, what are the options? What is mediation? Where does it fit? And what are the other options in reaching a family law agreement? Well, this table here shows a few different options. You may be familiar with some of them, but let me just introduce them to you. So the first step here, as you can see, is negotiation. And that might be negotiation between the parties themselves and you maybe getting some legal advice or providing that legal advice, and then the parties might negotiate themselves an agreement, or it might be through a roundtable settlement conference with lawyers present or lawyers negotiating on your behalf. This process is generally quite informal. Obviously, you have quite a lot of control over the process, and it's generally the most time and cost effective and generally the most amicable way of resolving matters. Then the next step up is family mediation, which I'll be focusing on today. But family mediation is really where an independent person, such as myself, is appointed to help facilitate the discussions between you and the other party with the lawyers present. We're not imposing an outcome on you. Ultimately, it's up to the parties to reach an agreement, but we help facilitate the process in a safe and structured way. Collaborative practice, just to introduce that to you, you may have heard that concept. It's about resolution without court. Similar to mediation, you do have lawyers involved. You generally do have a coach, like myself. I'm a trained collaborative coach who is facilitating the process, again, in a safe and structured way. But the collaborative process, you also sign a participation agreement that you will not go to court and that you will actually resolve the matter or try to resolve the matter through a series of meetings. So it's really pre-court phase, whereas mediation can be conducted pre-court or during the court process, and there's no restrictions on litigation in the future if it doesn't resolve. There are some good advantages with collaborative practice in that everyone involved is working as a team through a series of meetings instead of there being this war of correspondence that often happens in legal matters, and you're all working towards that common goal of reaching an agreement. The next step, arbitration. Arbitration is similar to litigation, and it's becoming more common in family law property matters where parties appoint somebody like me, but that person as an independent, but that person can actually impose a decision or what's called an award on the parties in a financial matter. So it's similar to a hearing. You might give the evidence and the arbitrator might hear some evidence, but it's a private litigation matter and the arbitrator makes a decision. And obviously litigation, the Family Court of Australia or the Federal Circuit Court of Australia, where a judge, perhaps after a series of court events, will ultimately impose a decision on the parties. So as you can see from these options, there's an escalating hostility generally, an escalating time involved, and escalating costs as you step up the processes. It's often more formal as you step up the processes, and you have less control of your relationship as parties, less control as to the outcome. Sometimes, even if you get to litigation, obviously you're not guaranteed an outcome that you're satisfied with, and sometimes neither party is satisfied with the outcome. So it's really important to look at what are the options. Feel free to ask any questions along the way. So is mediation suitable? Is it appropriate for you? So as a professional, assessing whether mediation is suitable, I have to assess whether the parties have the ability to negotiate freely. Some of the things I have to consider is there a history of family violence? Family violence is not just physical, it might be sexual, verbal, financial. It's all about control and coercive behaviours that impact a person and perhaps their ability to negotiate freely. I do have to assess the safety of the parties and others involved. I do have to look at the quality of the bargaining power between the parties, the risk that the child may suffer abuse, verbal abuse, emotional abuse, etc. The emotional, psychological and physical health of the parties, including I ask mental health questions around what sort of supports are they getting, do they have family support, do they have professional support to help them at this really difficult time in their lives. And any other matter that I consider appropriate. So before I actually conduct the mediation, I have to conduct what's called a mediation intake or a mediation preliminary conference. I generally conduct that for a couple of hours with each party separately. I do use a screening tool called Family Law Doors, which is an online questionnaire, and sometimes the Domestic Violence Safety Assessment tool. And in that intake, I do 5 things. 1, I introduce myself and how my mediation process will be conducted. Secondly, I get a background from the parties as to the issues that need resolution. Thirdly, as required under this legislation, I assess the ability of the parties to negotiate freely. Fourthly, I look at how they're communicating and perhaps make some suggestions as to how they can improve that communication. And lastly, I look at, if it is appropriate for mediation, what is the preparation for the mediation? And that's some of the tips that I'll give you today. So it is a process mediation. Some people see it as an event, a one-off event, but it is a process. Intake, preparation, and sometimes it's not just a one-off event, one-off mediation. It might be a series of mediations, perhaps looking at the parenting side, the financial side, etc. So the importance of looking at the ability of the parties to negotiate is really important in my preparation, but also you as parties and lawyers giving that relevant information to me to be able to assess that properly. Next, what are your obligations as a professional, or what should you know about the obligations of your lawyers and mediators? Well, a solicitor has the obligation of informing clients of the alternatives to fully contested adjudication of the case. So if you go in, or the other side goes in and says, I don't care, I just want to go to court, the lawyer does have an obligation to say, Well, there's alternatives to court. Have you considered mediation, arbitration? What are the alternatives within those mediation processes, etc.? There is an obligation on us as professionals to provide that information. Secondly, we as professionals need to give information to parties about the legal, possible social effects of the proposed proceedings and the services available to assist them. Most lawyers are not trained counsellors, not trained financial advisors. So it's important for us as professionals, and I do in my area, for example, have a good network of counsellors, psychologists, accountants, financial advisors to be able to refer parties to. And if you are a party, I do have that information of people who can assist you. Also looking at the steps, we need to advise the steps in the proceedings. It's not a case of you file an application in court and it's determined on the first day you go to court. Sadly, there's a big time delay in the family court, and therefore there's a number of steps involved, and us as professionals have to explain those steps and what the role of people like family consultants and what is arbitration, etc. Also, as professionals, we're required to give a number of brochures that are mandated that we give you, some about the services that are available in family law, some about your duty of disclosing financial documents, some about the requirement to participate in dispute resolution in parenting matters and financial matters before you go to court. So as a professional, be aware of those obligations which fall under your professional solicitors rules, but also the Family Law Act and family law rules. What are the obligations of parties? So the obligation of parties, sorry, I can't read that particularly well, but the obligations of parties include that you as a family, you need to participate in family dispute resolution if it's a parenting matter, before commencing court proceedings. So unless an exception applies, you need to meet with somebody like myself, a family dispute resolution practitioner, mediator, attempt to resolve the matter through a dispute resolution process. And if it doesn't resolve, get a certificate which is called a Section 60I certificate to say that you've attempted resolution. You do have to make a genuine effort to resolve the case, genuine effort in dispute resolution, and even if it's a financial matter, genuine effort to resolve the financial matter before you start court proceedings. And the court can in fact adjourn the case and even order costs if a party has failed to comply with pre-action procedures. You should be aware, as professionals you would be, and as parties many of you would be aware, that family law has been in the media quite a lot recently. There is a number of recommendations. Some of the recommendations include that there should be more mediation, more arbitration, and that mediations should extend as mandatory for property settlement matters as well as parenting. You'll probably notice that some of the government funding has gone towards property mediation, and that there are more and more options available for you now to resolve disputes without going to court. And it's really those worst case scenario of going to court. So hopefully you can resolve, or you can help your clients resolve matters without court. And that's definitely my mandate. So parenting, what resources do I give clients that are going through separation? Well, there's some really good parenting videos. There's a video here, won't show you at the moment, but it's a reference for you as to what the impact of separation might be on children. There's some really good videos that can really help parties get back to focusing on what's in the best interest of the children. Sometimes with all the emotions going on through the separation, they sometimes do, the children do get adversely impacted by the separation. And it's really important as a professional to focus your clients back in on the importance of what is in the best interests of the children and how are the children impacted and how are you going to co-parent effectively moving forward. There's also some parenting courses, some free, some paid. This is one that I find quite helpful, if you can see that on the system. This Up to Parents, it's American, so there is a little bit of mom and some American terminology, but this is a free course. It does take about 3 to 6 hours for parents to work through individually. It's an online course, and this course, there's some information in the video, etc. if you want to have a look at it. You do get a certificate at the end of this course that you can provide to the professional, to the court, etc., if necessary in the future. But I quite like it as it focuses on the individual needs of the individual children, and there's commitments that you make and goals that you make to really focus you in, as I said earlier, on what's in the best interest, what are the children going through. And this course and similar courses, Up to Parents, .org, are being mandated by some of the judges to complete a course in post-separation to look at how to best parent as separated parents. Other resources, My Family Wizard is another quite helpful one, Our Family Wizard. There are a number of post-separation parenting apps these days. If parents are finding it difficult to co-parent, communicate about co-parenting issues, there's a number of technology apps to help them co-parent. Our Family Wizard, DeVito, there's a few different ones. Reach out to me if you want a list, but that can really help you in your co-parenting relationship. There's also some good resources. There's a number of resources, some general, some specific to your situation. But this one I find particularly helpful from the Family Law Pathways. It's called Parenting After Separation. It does go into some information about the impact of conflict on children. The research suggests that it's not necessarily separation itself that's so harmful for children, but that it is the ongoing exposure to violence and conflict that has a real negative impact on the children, not just now, but into the future. So it's really important to look at how can you effectively co-parent. It does go into different models of post-separation parenting, being the ideal cooperative parenting model where there's trust and communication, a parallel parenting model where there's truce and there's structure and you co-parent sort of effectively by yourselves without too much stress on the children, or unfortunately conflicted parenting where there's often intense emotions and vulnerable children involved. And sadly, I do see people that generally fall into this conflicted parenting, hoping to move into the parallel parenting. I can give some tips around how to move from conflicted to parallel and ideally cooperative parenting. So it also goes into how to resolve disputes, what are the options available, how best to speak to your children, the importance of close relationships, not just with the parents, but other significant people in the children's lives. And then also I find very important, my background is in social science, the emotional stages of development of children. It's very different to being a parent of, or separated parent of children who perhaps fall into the 0 to 2-year-old age gap versus the 3 to 5 versus the 6 plus. There's different emotions attached. Sometimes with attachment theory, there's different attachments to one particular parent depending on what the circumstances have been during the relationship. So it's important to look at not just what the standard is, but what's your children's particular age, emotional responses, physical responses, what's the changes in any behaviours, how can you help and protect your child at their particular age. So there's some good information here around that and how to be patient, maintain continuity, being positive about the child, spending time with the other parent, and then more detail as to the children's general responses in those different age brackets. So again, I'd encourage you, there's a lot of resources out there. This one I find particularly helpful and something that I provide to my clients. That's something to look at. So as I said, think about with parenting and preparation for mediation, the importance of being in that right headspace. There are some courses, videos, and resources for you to have a look at or to encourage your client to have a look at. So financial matters. What preparation should you be doing for a financial matter, and how does the financial matter actually work? What are the steps involved? As I said earlier, in addition to my role as mediator, I am a legal tech founder of this product, Family Property, as well as another one, Law Switch. But Family Property really aims to look at the problem of that running a family property mediation and matter today is quite error-prone, manual, unstructured, can be quite time-consuming and can be quite complex. So what we aim to do with family property is make those property mediations, financial mediations, more accurate, automated, structured and simplified. And we do that, and you can see here the different steps, which I'll take you through shortly, from making an inquiry with a lawyer, to having an initial conference with a lawyer, to doing an intake, collection of the information, developing a balance sheet, getting some advice, making some proposals, a settlement negotiation, reaching an agreement, and that being formalised by a court. So they're the sort of general steps involved if in a family law matter, if it does go through settlement, negotiations, mediation, and where perhaps you might get professionals' assistance. But how does that work as far as what preparation in these stages of client intake, collecting the information and balance sheet, really should you be collating for a settlement negotiation or mediation? So what I'm going to do now briefly is just show you family property and some of the questions that are asked and some of the information that is required. Just bear with me as I log in here. Can everyone see that okay? Just make sure that I can see everyone. I might just stop there briefly and just if you have any questions, please let me know. I'll bring up the chat section. Thank you. Okay, so can everyone see, if you just want to type in that chat box, that you can see my family property, that would be helpful. Can you just okay, so I'll just introduce you briefly to family property. So it's an end-to-end product. What we do is we enable you to do it as a single party or as a representative, being say a mediator or an arbitrator. In the questionnaire, I'll go straight into a questionnaire matter. Party can put in, say, Fiona, type here, Kirkman, Fiona Kirkman, questionnaire mode, Tim Kirkman. You can invite your client to participate in the, to complete the questionnaire, which I'll show you shortly. And if I go into the questionnaire here, I'll just launch and show you the type of information that needs to be obtained for a family law property settlement matter. So as you see here, this is an online questionnaire with drop-down menus. It's quite in plain English. It's been adapted from the Family Court's quite complex financial statement. And what we do is we go through different steps involved in the matter. So firstly, personal details, quite self-explanatory, dates of birth, etc. Then relationship details. So when did you start living together, whether you're separated, divorced, married, de facto, and some dates around that. Some information about your children. So if yes, then add some details around the name, gender, date of birth. Is there children from previous relationships? What are the current living arrangements? So who's living in the house? Where are the children living? Is child support being paid? Do you have a new partner? Is there spousal maintenance or financial support being paid? All relevant to an assessment of the financial matter. Income and expenses, so information around employment will be important. Details of employment, you can add multiple employment if you have multiple sources of income. Some basic expenses information here around what your rent is, council rates, quarterly rates, etc. If you don't know this information, you can just go straight on to the next question. This can be completed by the lawyer or, as I said, by the party themselves. And this language will actually change if you're completing it as a party. It will say, are you employed versus is Fiona employed, etc. Assets and super, so obviously this is really important. Looking at the family home, household contents, bank accounts, vehicles, investments, business interests. And it's quite straightforward in that no business interests, no, move on to the next question. Whereas if there is business interest, there's then a whole list of questions, again in plain English, as to information for that business. Or if you're like me, multiple businesses can be added there. Same with superannuation, type of fund, whether the name of the fund, type of fund, the value of that super fund, etc. So it's a really straightforward way to start understanding what type of assets you need, because when you look at a property settlement, so for those that aren't that familiar with property settlements, it's really looking at 4 steps. 1, what is the identity and value of the assets, liabilities and superannuation? So this is really gathering that information to assist. So this is the first step. What are the assets, liabilities and super? Secondly, looking at contributions, so, which I'll show you in a moment. Thirdly, looking at future needs. And lastly, looking at what's just and equitable. So if we look at those 4 steps, this is focused on what are your assets and super. The next step is looking at what are your liabilities, so mortgages, credit cards, tax debts, other loans, other debts, etc. Next, giving an understanding as to what the other side has by way of assets, super, liabilities. Then, as I said, in that second step of contributions, it's really looking at what is the past, what's happened in the past. So when you started living together, so at commencement, what did you both have? If there's nothing, no. If yes, then you add what type of contributions, etc. During the relationship, did you receive any significant lump sums? So it specifies here in the questionnaire, inheritances, financial gifts, damages awards. Did you do significant renovations to the home? What about unemployment, etc.? So ask specific questions to really guide you as the professional or the party as to what sort of contributions might be relevant. And again, post-separation, has there been any significant changes since separation? Because it's important to note that the value of the asset pool is actually looked at as at the current date, not the date of separation. So significant time may have passed since separation. Lastly, it's looking at future needs, or what some professionals might refer to as the Section 75(2) factors. Things such as, are you going to be the primary carer of the children? Is there a difference in your age or state of health, physical or mental? Is there a difference in income earning capacity? There is no formulaic approach in family law property settlement matters. So every case is looked at its individual circumstances. But what you do need to do is look at, as I said, contributions. What's the percentage roughly? Is it equal or more in favour of one party or the other? And then for future needs, should there be an adjustment because one party's future needs might be adversely affected? So any questions about that? I'll just see if there's any, I can see it, that's fine. So if you have any questions about how you look at a property settlement, please ask now. So once you've submitted that questionnaire, the benefit of using family property is that it brings all of that information together in that what I've done is looked at what does the legislation and the family law rules require you then to disclose by way of documents. So what I've done is I've brought across, if you've disclosed, say, I have a house in Albury, I have a bank account, I have a business interest, I have shares, I have a trust, etc. I've then brought across what documents do you need to disclose. So for the house, for example, it's important to get a value on that house. You can do that by way of market appraisals or an online valuation or a formal valuation. Bank accounts, the bank balance summary statement, bank account statements. Business is different. Business activity statements, financial statements, trust deeds, etc. Shares, so the share statements, cars, registration papers. So it's important to gather that financial information. You actually have an obligation, which is in that brochure that I referred to earlier, of a duty of disclosure to disclose all of the relevant financial information about the matter. And this is a really good, secure platform to enable you to do that. And you can do that by uploading from your phone or computer, pressing browse, and you can upload those market appraisals or other documents. They will automatically be given a title. You can put a comment as to why you've uploaded them. And you can see here all of the information will be displayed. Also with this secure client portal, it's not just asking for information about the assets, liabilities and super as you see here, but if you've put in, say you received an inheritance in 2016, it'll ask for documents because it's important to confirm with some evidence the documents that you have to support that. And it will also ask for information about income because that's a requirement, as I said, under the family law rules to provide information about tax returns, notices of assessment, pay slips, etc. So that's something, when we look at preparation, that's a client questionnaire that I get my clients, if it's a party only mediation, to do, and then the documents to upload. What I then do as a mediator, there's a mediator version or a lawyer version, is I go into the dashboard of each of the parties, and I can go to Flynn, in this case, Flynn's case, Molly's case, or both cases, in a neutral balance sheet. And the benefit of doing the online questionnaire is that all the information is then auto-populated. So I can use this balance sheet, as you can see, without going into too much detail today. It's all auto-calculated as to the assets, the liabilities and superannuation. It has sub-balance sheets of, say, the family home. It also has connected liabilities, say, for botany with the mortgage and real estate fees. The benefit of this is I can model proposals. So I can model if a client, if you're a lawyer or if you're looking as a party at a 50-50 split, I can model what does that look like with a cash adjustment or an asset super split. In this case, look at a 50-50, and you can see here 50-50, and then there's a cash payment to Flynn from Molly in both the assets and liability side. And if you see, I use these sliders here, and you'll see that the figure changes. So how we see this balance sheet is really an Excel spreadsheet on steroids, in that it enables auto-calculated, but it does have all of those documents attached to it that may have been disclosed. It has the ability to have chronology entries. So if the house has been refinanced or renovated, you can tap into the relevant date that those renovations were completed and add that, and that will go into a chronology. You can add values, estimated values, what your proposed action is, etc. So it's really helpful. It also gives you guidance as to perhaps things to do as a professional. So an info track search is a title search or a valuation. For example, the car, if you wanted the value, you might do a red book search or an NRMA search to look at what's the value of that car with the type, model and age of that car. Shares is another example. You might do an ASX search, to look at, you might have 100 Telstra shares. How much are the Telstra shares worth as at today's date? So they're really good. It's really important to do that preparation, as I said, in that step 1, to identify and value the asset pool. You can save multiple balance sheets. So if you're modelling a 50-50 or a 65-35, save those different versions so that then you can put them forward to the other side or just have them for your reference. Obviously, there's personal details that have come across, as well as considerations. So remember, when we looked at step 1 is the asset pool. What's the identity and value of the asset pool? When we look at step 2, it's the contributions. What did you have at the start of the relationship, during the relationship, post-separation? This brings it across again in a very user-friendly way, where you can add additional information, you can upload further information, and you can really see what were the contributions overall, equal, higher, lower, and make comments about that. Lastly, in step 3, looking at future needs. Is there a difference in income earning capacity? Is there a difference in age? Perhaps the age here may need to be changed, because an 85-year-old primary carer might be rather interesting. But yes, it's looking at, should there be an adjustment for future needs? So all of this, in my experience as a family mediator and a lawyer, is really important to adequately prepare for the mediation. We might come back to family property right at the end, just to look at how it can be used to document an agreement. Just in answer to your questions that you may have, there is a document automation engine here as well, which brings out the balance sheet in Word or Excel spreadsheet, those proposals in Word or Excel spreadsheet, the chronology, the attachments, the recommendations, considerations, etc. I'll come back to the heads of agreement in a moment. Any questions about that? Any questions? No? Okay, well, I might move on back to the presentation now. Won't be a second. Okay, so as we've discussed, coming back to the pause principle, the importance of preparation. So I've covered a bit generally as to the importance of preparation is the key to success. What are the options? Is mediation appropriate? What are your obligations as professionals? What are your obligations as parties? What are some parenting resources that can help the clients and parties going through this? How can family property assist in the preparation of a financial mediation? I then now want to move briefly onto the other principles in the pause principle, the next being affirm relationships. Now, parties sometimes come to lawyers and they're very emotionally stricken. It is quite normal going through the grief process that they will be perhaps in denial and shock. They will be angry. They will be depressed. It's perhaps unlikely that they'll be, both, particularly if you're a mediator, both in that acceptance and wanting to move forward, and it's all very amicable. There are emotions involved, and we do have to manage those emotions as parties and as professionals. The importance of, as I said earlier, remembering that you are the parties, if they do have children, will always be parents. They may no longer be partners, but they will always be parents, no matter what the age of the children, and to effectively co-parent is really important. Also, in a negotiation, I've done some training. I teach at the College of Law on negotiation and dispute resolution, and the importance of understanding when you're negotiating, the importance of what is your negotiation style? What is the negotiation style of the other party or the other professionals? Is it competing? Is it accommodating? Is it compromising? Is it avoiding? Or is it collaborating, which is, in my view, ideal in a family mediation collaborative process. So it's important to assess that when looking at and going into a family mediation. Understand interests. So is the next principle, you understand interests. As I said, it's not just about this is my position, this is your position, but looking at what is in the best interest of the children. I often use this orange analogy, and looking at if you were to break the orange and both parties wanted the orange, how could you do that? How could you both have the orange? And some people might say, well, let's just cut it in half. And you'll be surprised, sadly, some people in family law just say, let's cut the time in half with the children, or let's cut the finances in half. 50-50 is fair. That may not always be the case. It may not be the case that a 50-50 is fair. Instead, what I encourage parties to do is look at looking at why do you want the orange? Why do you want the orange? And the analogy with this your case is looking at perhaps asking the parties, why did you want the orange? Well, I wanted it for the rind, whereas the other party wanted it for the juice. And therefore, both parties' interests were able to be satisfied through asking the why question. So taking that back to a family law context, there is positional preparation and there is interest-based preparation. We've covered some of this, but the importance of disclosure, as I've said, the importance of obtaining advice, not just legal advice, but financial, mortgage capacity. Should you prepare a position paper? What evidence should you have? What offers should be made, by who, what, and when? And what should you use family property? What other preparation should be done? So that's traditional positional preparation, but also interest-based preparation. What is the why? Why are this family in conflict? Why are you in conflict? What are the underlying interests? If you look at the iceberg, what are the hopes, concerns, and fears of these parties? Is it that they don't want to move out of the house? What's that ongoing relationship going to be? If they destroy each other to get that extra 5%, is that going to impact their ongoing relationship? What can you do to expand the pie? Not just to look at the dollars, but perhaps other things that are important to one party, but may not be so important to the other. So S is the next one, search for creative solutions. So I use these de Bono hats of thinking outside the square, looking at the yellow hat, the optimism, what are all the best options, what's the worst situation, the black hat, what are the emotions around it, green hat, the creativity, the blue hat, the thinking, the logical decisions. But what are all of the options available? Not just the ones that the parties have or you perhaps have as the lawyers or the mediators, but what are all of the options and perhaps what works for everyone before you start evaluating. So really think about, as I said, searching for creative solutions. Lastly, evaluating options and reaching an agreement. That E, evaluating options. So when evaluating options, this BATNA principle, Fisher and Urey, looking at what is the best alternative to a negotiated agreement. So as I said earlier, it might be that you've had advice that 55% is the fair range, or you should have 4 nights a fortnight with the children, etc. But what does that actually look like in practice? If you don't reach an agreement between yourselves or through the use of family mediation or another dispute resolution process, what does that alternative look like? What does, for example, court look like for you as a family? What does it look like for your client as a family? It's not just the outcome and the extra dollars or extra night, etc. It's the time. You might spend years and years in court. It's the money. Sometimes people spend hundreds of thousands of dollars in legal costs, even sell their home to pay lawyer fees. The stress on you as a party or client as a party, but also these children who are often caught in the middle of it, particularly if it's going through litigation, and the impact that that has on your relationship, on your dignity, on your ability to function in everyday life. So really think about, as a party and as a professional, looking not just this is the outcome and whether you should settle or not, but what are all of the other impacts? And lastly, what agreement documents should be prepared? For parenting, you can have an informal agreement with no formality around it, or you could have a parenting plan, which is in writing, signed and dated. It's not binding and enforceable court orders, but it would be taken into consideration by a court. For financial matters and for parenting, you can also have financial consent orders if it's by agreement. And you do need to fill in an application for consent orders, which I'll show you briefly, and consent order documents, and some other documents depending on what the issues are. Alternatively, in financial matters, sometimes there's a binding financial agreement, but that's generally not recommended for situations because of the risk involved for law firms, etc. these days. So if possible, if it's post-separation, if you need orders for parenting and or financial, it's consent orders and the application for consent orders. And it's strongly recommended in financial matters. Some people take the view that, oh, well, very amicable, let's just sell the house and divide the proceeds. Might be 50-50 or 60-40 or whatever it is. That's not a formal property settlement. And what I have found over the 16 years of practice is that often people come back to the professionals and say, well, I never did a formal property settlement. I want more now. And that's really problematic, particularly if the situation hasn't changed, you've received an inheritance, the lottery win, etc. It's important, even if you don't have a lot, to actually formalise the finances into a consent orders. As I said, parenting, if there's parenting, you can do a parenting plan or the parenting orders, depending on the situation. Just to show you what those documents are for your benefit and how we use them in family property. As I said, heads of agreement. Hopefully you can see this coming through. If you can just confirm, heads of agreement. Might be a moment. Okay. Good. So as you can see here, the heads of agreement actually brings across if the parties or the professional has put in any dates, so dates of birth, dates married, commenced living together, that inheritance, renovations, when they separated, the refinance on the home, the ADVO, the second refinance, the works completed. It then brings across not only the financials, but that the agreement into wording and categorises that. So real estate, that within 90 days, the parties will sell the home. At botany, the estimated split is X and Y. Motor vehicles, who will retain. Bank accounts, what will happen. Business, investments, other, superannuation. These are not orders. You would need a lawyer to assist in the drafting of orders, but it really gives an indication as to what is to happen with those assets. As you saw with the sliders, who's retaining what, this is the wording as to the agreement reached. It also has financial effect, which is quite helpful in looking at who is retaining what. The Flynn split, Molly split, what's the cash payment going to be? What does that equate to in assets, liabilities, super, and who's retaining what? And what's the overall outcome? And what does in dollars, and what does that equate to in a percentage? So the benefit of this is in Word format. It's a template, so you can change it, and it's really a really good automated start in reaching an agreement and documenting that. So that's a heads of agreement, which is not formal consent orders, but you might want to have that initially if you've gone through a mediation, and then you may want to draft it into formal consent orders. So I'll just show you this form by way of formal consent orders. Just show you this, make sure it's coming up. As we saw in the heads of agreement, it brings across that information into wording as to what the heads of agreement is, but it is in the proper form, whether it's the family court, which is the family court is the court that you would file consent orders if you haven't commenced proceedings, whereas if you are in court, you'd generally be in the Federal Circuit Court. Lastly, before I take questions, this application for consent orders form, this automates this application for consent orders form, which is quite a lengthy, tedious form in some respects, but I've got the kit here. So if you're a party, the application for consent orders kit, which is on the Family Court's website, is quite helpful because it goes through some wording, what's the terminology you need to know, what are the relevant legislation you need to know. I'll skip down, but as you can see here, it's automatically populated if you do use family property, details about the party, the relationship details, the children's details as I've come up here, and then moving right down to the bottom, the financial details. So it asks for details around income, child support, and then property, again, dividing it into real estate, motor vehicles. You'll see extra boxes for the extra motor vehicles, furniture, funds in bank accounts, what the totals are, the liabilities, and then the total net worth, excluding super, if there's been assets disposed of, the superannuation, what's the value of that, financial resources, what the total split is. And then it does ask those questions around contributions. Remember step 2, what's happened in the past by way of financial contributions, non-financial contributions, homemaker parenting tasks, as well as these what's called Section 75 or future financial needs. Lastly, it gives the effect of the property owners, all again automated calculations, which is a really good start in looking at, this is again a Word document, in getting you started with formalising that agreement. So that's the capacity of family property. Last thing I'll just show you, just noting the time, is that as a mediator and as a professional, you can also go from Flynn's side to Molly's side, and there is also a neutral balance sheet. So the neutral balance sheet brings across both parties' formal offers in a mediation, and if the figures are in agreement or disagreement, it will go green or red. So this is a very good comparison tool to bring Flynn and Molly's side by side to look at, again, auto-calculated, the assets, liabilities, superannuation. Is there an agreement on the identity, ownership and value? And is there an agreement on the proposed, the proposals as to what's to happen? It does bring across the considerations so that you can go through with the parties. Well, why do you say 50-50 when there was $1 million brought into the relationship? So you can actually compare what each party is saying as to the relevant contributions and future needs factors. So I'll have to stop it there, noting the time, but let me take any questions that you might have. And the document page to open them. Okay, so hopefully, Oriana, you can see that now. If you've got any questions, please let me know. Please feel free to reach out to me as well. I'll give you some information about, feel free to ask any questions if you have any. Just some information about family property and Kirkman family law. Family property, the pricing is a per firm approach. We don't yet have a party approach, but we do have a per law firm or per mediation firm annual fee, and then a per matter approach of $85 per matter. Further information on our website, or feel free to reach out to me via email. And Kirkman Family Law, our website here, Kirkman Family Law, I do a lot of online mediation as well as mediation in the Sutherland Shire, Sydney area on a face-to-face basis. I have recently employed a second mediator to help me as well with mediations. Question here, I'm just wondering, you mentioned in relation to domestic violence, were they, so the two screening tools that I mentioned, there's family law doors as well as family law doors, which I'll just show you briefly. Bring that up. So family law doors is here. So family law doors, it's a free tool that you can use, and doors tool, family doors app, and you can register, log in and register, and you can then send a secure link to your client to complete the online questionnaire. The second one I mentioned is called, it's New South Wales based. They are looking to have a Commonwealth one that's uniform, but the one in New South Wales that I use is the Domestic Violence Safety Assessment Tool, which is what the police often use with some risk assessments, etc. And again, domesticviolence.newsouthwales.gov.au. Any other questions? No? Okay. Well, I might have to end it there, noting the time, but I do very much appreciate you taking the time to sit in on this webinar. Do reach out to me should you want some further information about family property, our legal technology tool that's for lawyers and mediators to help you from beginning to end in doing a family property matter, or do reach out to me about mediation services or mediation tools, because I do some training for mediators as well. So thank you very much, and I'll end the webinar now. Thank you, all the best. Thank you for your messages. Thank you, bye.